discuss the recommendations from the CADA Rewrite Subcommittee. We met yesterday and discussed most of the recommendations regarding government and access to government employment and elections. We will have a continuation of our discussions next Monday from 9 to 11 a.m. of any issues that we did not get through yet. Today we'll be focused on these issues. Because several of the letters of input from state agencies were just circulated to you over the last few hours, I'm going to take some time right now and read through those. One of them is from CCRD, and it contains two specific comments on items, so I will hold those for when we're reviewing those. But the first letter is from the Colorado Office of Economic Development and International Trade, and its Executive Director, Eve Lieberman. The letter reads as follows. Dear HB 23-1296 Executive Committee members, thank you for your dedicated service and extensive work over the last year to formalize recommendations to protect the civil rights of persons with disabilities. The Colorado Office of Economic Development and International Trade works with statewide partners to create a positive business climate that encourages dynamic economic development and sustainable job growth. We strive to advance the state's economy through financial and technical assistance in support of local and regional economic development activities throughout Colorado. We envision a future where our quality of life continually improves. Great jobs and affordable housing are readily available, economic mobility and resiliency exist, and environmental stewardship is a priority across our great state. Our mission is to create a Colorado economy where all can thrive. We commend the task force's goals of better preparing our communities, businesses, and natural lands for Coloradans living with disabilities, and ultimately striving towards a Colorado for all. Rather than provide specific feedback on the cross-cutting task force recommendations, we want to elevate feedback and input submitted by the business community, including small businesses, outdoor recreation, and housing leaders. We strongly encourage the task force to consider the perspectives and feedback submitted by the Colorado Competitive Council, Denver Metro Chamber of Commerce, the Colorado Chamber of Commerce, and other private sector companies and associations. Next steps taken towards implementation of pending recommendations should include meaningful participation from all impacted parties and must be viewed through multiple perspectives in order to strike a balance that honors the intent and vision of the task force recommendations while operationalizing in a way that allows Colorado to remain an attractive business environment with a thriving economy that lifts up all of our residents. As noted, OEDIT's mission is to create an economy that works for and meets the needs of all Coloradans, and the administration remains committed to working with the task force to ensure that Colorado is the best place for business and the best place for individuals with disabilities. Based on the current recommendations, we support the industry feedback that additional work is needed to create reforms that avoid imposing excessive economic risks on businesses. We appreciate all of the thought and discussion that has gone into these recommendations. The impact of these recommendations varies significantly across state agencies, and we recognize that several agencies have separately and jointly submitted specific feedback to the task force, while our letter is intended to provide high-level feedback in support of the concerns raised by business in Colorado. We look forward to the continued collaboration and engagement as these recommendations make their way through the process. Sincerely, Eve Lieberman, Executive Director of OEDIT. The next letter I will read to you is signed by 4 agency directors, including the Department of Personnel and Administration, CDLE, HCPF, and the Department of Corrections. It reads as follows. Dear HB 23-1296 Executive Committee members, thank you for your dedicated service and extensive work over the last year to formalize recommendations to protect civil rights of Coloradans with disabilities. Executive directors from agencies impacted by the recommendations provided by the Colorado Anti-Discrimination Act, Rewrite Subcommittee of the Task Force on the Rights of Coloradans with Disabilities, submit the following feedback for your consideration. Collectively, we share the task force's commitment to ending discrimination in Colorado. We support parity across collected classes, as well as the comprehensive and expedient resolution of cases of discrimination, and we are supportive of voices advocating for reasonable modifications to CADA. We are in favor of aligning civil rights protections, timelines, processes, and damages across all protected classes, as well as with federal definitions where feasible. Aligning these protections and improving case efficiency benefits both claimants and respondents. Providing sufficient timelines to file discrimination claims is important. However, it is also important to be reasonable about the length of time between the discriminatory event and the filing of the claim to ensure adequate records are available and to ensure that individuals with knowledge of the events have not changed their career paths in the interim. The assessment of financial damages to provide compensation to individuals who have been discriminated against is a valuable step towards remuneration and can serve as an important deterrent to discriminatory behavior. It is also important to avoid imposing excessive economic risks on businesses, governments, and other potentially impacted actors. When assessed, financial penalties should correlate to the nature of the violation rather than depend solely on a subjective assessment of an individual's emotional distress. Current damages available for employment-related claims in proportion to the size of the employer and those available for housing-related claims are based off of any other recent discriminatory actions by the respondent are a good model to consider. Under current law, only claims for employment discrimination require exhaustion of the process administered by the Colorado Civil Rights Division. We are concerned that the recommendation as written could apply to administrative processes at individual state agencies that allow for remediation and for accommodation needs to be met. It is important that agency administrative processes for addressing discrimination concerns remain in place as these allow the fastest path to resolution. The administration remains committed to working with the task force to ensure that Colorado is the best place for individuals with disabilities. Based on the current recommendations, it is our assessment that additional work is needed to create reforms that are effective and financially feasible. We appreciate all of the thought and discussion that has gone into these recommendations. The impact of these recommendations will vary significantly across agencies, and we recognize that several agencies have separately submitted specific feedback to subcommittees, including this one. This letter is meant as high-level feedback rather than a response to individual recommendations. However, given the impact of these recommendations, we deemed it most appropriate to pen a collective letter. We look forward to the continued collaboration and engagement as these recommendations make their way through the process. And finally, as I mentioned, we do have a letter from CCRD that speaks primarily to two recommendations, but I'll read the cover letter now, and then we'll get into their specific feedback on those two items as we discuss them. This reads as follows. The Department of Regulatory Agencies, and more specifically, the Colorado Civil Rights Division, have reviewed the recommendations from the Task Force on the Rights of Coloradans with Disabilities, Colorado's Anti-Discrimination Act Rewrite Subcommittee, and appreciate the work and extensive thought that's gone into the recommendations. CCRD is a neutral, fact-finding administrative agency that enforces Colorado's Anti-Discrimination Act. CADA prohibits discrimination based on protected class in employment, housing, and places of public accommodation. The CCRD enforces CADA by investigating complaints of discrimination, mediation, and education. Persons with disabilities are deemed a protected class under CADA, and their rights are in parity with those of other protected classes under existing law. Current law requires any person claiming to have received discriminatory treatment in employment, housing, or places of accommodation to file a charge with CCRD. According to the statute, CCRD has 450 days of jurisdiction time to complete this administrative process. The division's overall budget is supported by federal funding via workshare agreements with the U.S. Equal Employment Opportunity Commission, the EEOC, and the U.S. Department of Housing and Urban Development, HUD, as it relates to investigating complaints of discrimination that have shared jurisdiction. The comments below capture our present commentary concerning subcommittee recommendations. We have done our best to call out where we believe that subcommittee recommendations are in harmony with our agency's responsibilities and mission, as well as where there are operational, financial, or other considerations that need to be considered when evaluating the idea. This is not an exhaustive analysis, nor do we intend to convey a final recommendation analysis. This commentary is intended to inform the executive committee as it makes its final decisions on each recommendation. With that, Lieutenant Governor, do you have any opening comments before we go into a discussion of each individual recommendation?
I don't think so, Barrick. I think we have a lot of material to cover, and I think we ought to just get into it. I just really appreciate, again, as always, everybody's work and your wordsmithing. So let's go.
I will continue to do my best, and I appreciate Representative Ortiz.
Yeah, I think it's interesting that, we don't get these, first of all, that we don't get these letters until 2 hours before we're supposed to meet, which is I think, indicative of, in my opinion, how seriously they're taking this. And then also the fact that they could have influenced or shaped a decision any time along the way over the past year. And it also tells you, it's very indicative of how they feel about what we're about to discuss. There's a real opportunity to finally secure basic access and basic human rights for people with disabilities. And it's very apparent to me by these letters that they're big scared about it, because obviously they've gotten feedback from many in the departments and many in the business community, which they do have members on the subcommittees and access to the executive committee. So I hope everybody read between the lines and is paying attention to what those letters said, and y'all are ready for the fight ahead. So let's get to work.
Madam Chair, Mr. Vice Chair, thank you both. I will go straight into the discussion today. As I mentioned at the top, we have a total of 12 recommendations to work through. 3 of those are strictly definitions that are primarily pulled from federal code. We have 9 substantive recommendations in addition to those. As we did on some previous discussions, I'm going to also include the language that the subcommittees identified regarding the problem to solve and the intended end state. Our first recommendation is to make exhaustion of administrative remedies optional. The problem the subcommittee identified was that current law requires any person claiming to have received discriminatory or unfair treatment to file a charge with CCRD promptly, and the investigation process may take 450 days. If probable cause does not exist, notice of charges will be distributed and dismissed, and the charging party can file a civil action in court. If the charging party fails to file within existing deadlines, no district court shall have jurisdiction to hear the action. If probable cause exists, compulsory mediation is ordered for both parties. If the resolution is not reached during mediation, the commission may set the case for hearing. Their recommendation is to amend Colorado revised statutes to remove any requirement for exhausting administrative remedies where such requirement exists relating to claims of discrimination, while preserving the right to pursue such remedies at the option of the claimant. We do have a specific comment on this item from CCRD that reads as follows. The state does not have the authority to exhaust administrative remedies on behalf of the federal government. The EEOC requires administrative exhaustion for CCRD to investigate cases for EEOC before filing in court. Individuals who allege that they have been discriminated against in an employment setting must first exhaust their administrative remedies by filing a complaint with CCRD. A civil action is filed if a complainant goes to court. The division has contractual work-share agreements with HUD and the EEOC. Per the agreements, when Colorado and the federal government share jurisdiction, the division is federally compensated to investigate on behalf of the federal government. These dual-filed cases comprise 68.9% of CCRD's employment caseload. According to our work-share agreement with our federal partners, CCRD would not be able to bifurcate cases to conduct a separate analysis for CAUTA and federal law. Further, CCRD will also require legal guidance on a variety of procedural matters. We additionally anticipate feedback from EEOC on how this and other recommendations will have impact from their respective perspectives. I'm going to now open it up to members of the executive committee for comment and to share your thoughts on this, or for questions of clarification. I will go to Hillary first.
Thanks, Eric. I also would like to, I appreciate that agencies and departments have taken time to give feedback. But I am also frustrated that we received this from, DORA and CCRD like an hour and a half ago, or 2 hours ago. Because I think this set of recommendations is probably the most technical out of all of the sets of recommendations. And, there are multiple of us on this task force who have legal backgrounds and law degrees who really could have dug into some of these concerns had they been raised, mixed signal.
Anytime in the past year?
Yeah. And so, you know, I agree with this recommendation. I think it is patently unfair that people have different amounts of like requirements around, you know, exhaustion. And I mean, I would also say I don't know how the EEOC will react. I wish I had had some time to do some research, but I would also say that at least from my organization's perspective, CCRD does not always do the best job investigating disability discrimination claims. And so maybe it makes sense to break from the EEOC here. I mean, I really wish that we had some time to, you know, we have relationships with people in the EEOC. I would have loved to have had time to chat with them about this concern and with CCRD about this concern. So, I hear the concern. I'm sorry it was raised so late. I'm in support of this.
Understood. And Hillary, I need to offer some clarification, not in any way to take away from any comments that are being made. For full transparency, I received the letter from CCRD and from OEdit yesterday afternoon as we were having our other discussion. I was expecting an additional letter, which is the one that I read out. So I chose to hold those last night until I received the final one. That is
Eric,
entirely on me.
Not to interrupt you, and this
Yeah,
isn't on you.
I appreciate that.
I-
I appreciate that transparency.
Yeah.
Even if I had gotten it yesterday afternoon, I would not have had time.
No.
to
And I
even
understand
I
your
okay, I
point.
just want to make
Yeah,
that
I
very
understand
clear
yours and
that
Representative Ortiz's point. I just want to make sure that the record is clear that that overnight delay was on mine. The other thing is for clarity, and I absolutely hear everyone's point about the desire to have a conversation about the EEOC. The subcommittee did discuss some of that. They heard the feedback and these concerns, and they put forward this recommendation having heard that concern.
Okay, and if I'm allowed to now.
Please.
Yeah, thank you. So again, like, don't beat yourselves up on an overnight delay. That an afternoon also speaks to just the lack of total respect and seriousness that I believe that they're taking this under. I am not surprised. I think the timing and the statements themselves are very clear, in my opinion, that they are not truly interested in bringing forward solutions and in solving the problem. Rather, they are interested in the status quo. Because Hillary is right. The cases that go through CCRD do not get resolved and do not get taken seriously. And there's no detriment to them for not doing so. We did this last year in stripping their ability to administratively have to go through administrative exhaustion 2 years ago with everything else except for employment law. And an example that are cited are a person was not allowed to stay in a hotel because he had a service dog. And they could not get the hotel owner to come to the table because they're not legally required to do so. There's no legally binding teeth on with the CCRD to make sure that they're securing the actual civil rights of people living with a disability. And so that's why we stripped it from their purview when it comes to everything else except for employment law. Employment law is no different, except it's worse because you're talking about people's livelihood. The stereotype of us being completely dependent on the system and lacking opportunities is a direct result of our basic access, basic needs, human needs, not being accommodated. That's a direct result of why we are 25% more likely to live below the poverty line. And instead of engaging every step of the way and offering real feedback in a timely manner so that this body can do its work, we get a letter a day before with no real alternatives. Just, oh, we don't like this. That's a very clear message, whether they mean to be that clear or not, at least to me.
Understood. Ms. Moran.
I just want to start with a slightly different interpretation of the timing. I am not offended by the timing, given when the recommendations came out and were published and people were made aware of them and the holidays. And as someone who is swamped in email right now and probably disappointing several people that I'm not being timely in my follow-up because I just landed back in the office yesterday. So I think I have a little different interpretation of the timing. So I just wanted to go on record as saying that, but I certainly appreciate the frustration that's being expressed here. My question about this is, and actually, Representative Ortiz, you hit this one on the head for me when you talked about timely responses, like getting timely feedback and resolution to cases is not something that has been seen here. And so I guess I'm wondering, when they were discussing this particular one, I do see that there was one, it was a 7-1 vote. I'm a firm believer in exhausting administrative processes on one hand. On the other hand, because I think that that's important, that people don't just go around, right, and get sort of sue happy, for lack of a better word. However, I do have grave concerns about the timing of this. And so I'm wondering if in these discussions, when I read the problem to solve and I see that the process may take 450 days, that's ridiculous to get an administrative resolution. I mean, there are so many, there are other processes. I'm trying to rack my brain and say, are there other administrative processes where I would not know whether or not I needed to file a case for over a year and a half? I mean, that seems pretty extraordinary to me. So I'm wondering if there was any talk about changing sort of the time that is allowed for these administrative processes to take place.
Ms. Moran, there was not. As you know, there's another recommendation that relates to aligning statute of limitations for filing all cases. The discussions on this were solely about releasing a claimant from the obligation to go through the process of administrative remedies, and specifically enabling or empowering them to go directly to court litigation rather than going through the administrative process. As I recall, and I may not have a perfect recollection, but there was no substantive discussion that the 450 days was the issue. They did have some discussion of were there sufficient attorneys who would take on cases to go this direction. But the conversation was more about enabling someone to make that discussion to go direct to a civil litigation. And I see hands up from Jennifer Harpole, who I'll go to first, and then to Kirsten. I do also want to just, and again, I take no position. This is absolute transparency. CCRD did provide their position on this to the subcommittee. I think it was back in April and May of last year as they were discussing this item. So the subcommittee heard their take during the process and went the direction that they did, including the additional public input. Jennifer, let me go to you and then to Kirsten.
Thank you, Jennifer Harpole. Yeah, so I was present in the subcommittee meeting where the CCRD director was there. So I just want to also add my perspective that they were involved in this process all along. It's not like they just swooped in yesterday for the first time, though I appreciate the concerns with not getting this particular letter earlier. So a couple points that I wanted to raise practicing law in this area. The first is that if you've been sitting with the agency, the charge has been sitting with the agency after 180 days, you can request your right to sue notice and go to court. So you don't have to wait the entire time if the agency has not timely investigated your charge. So that process is already in place to shorten. It's only, if you want the agency to make its determination that you would wait. But, we regularly see, especially when folks have attorneys, that their attorneys will request that right to sue notice and go ahead and go to court. So Just wanted to make sure everyone knew that process was in place. The other thing I would say is that, rare is the case that we see alleging only disability discrimination. It's often in combination with claims of other types of discrimination, such as race or gender or age. And all of those types of claims require the exhaustion of administrative remedies. So, um, you know, doing this piecemeal does not strike me as an efficient way. And look, I understand the arguments of, start somewhere, and folks may argue that we shouldn't have to exhaust for anything, but just putting it out there that this would be a very piecemeal solution. And then it also would be inconsistent, of course, with the requirements under federal law. Thank you.
Thank you, Jennifer. Let me go to Kirsten and then Hillary.
Well, thanks, Barrick and Jennifer. I think you hit a lot of the comments that I had. And I also I have been on the employer side of dealing with discrimination claims and everything else. And unfortunately for me, in my experience, I have had a number of these claims I've had to look at. Only once was there actually a real issue, and I'm not saying that as an employer trying to stand on it. Like, there was a lot of craziness there. So part of what I appreciate about the exhausting of remedies is that it creates an opportunity to make sure that there's actually valid claims that go forward, which is a real issue. And I also have a real issue with varying processes. If we have a problem with the exhaustion of remedies in the administrative process, that's an administrative process issue. That shouldn't be specific to just these types of claims. So I really have a problem with it.
Thank you, Kirsten. Hillary.
So I hear the argument around, it shouldn't be different classes, and I guess I stood on the side of like there should be no exhaustion for any class or any claim. And unfortunately the scope of this task force is specific to disability, and I think we always kind of knew, or at least some of us did, when we passed the 96 bill to create the task force, that the kind of subcommittee was always going to be sticky and complicated because there are sections of Connor that apply, at least disability, and then there are sections that touch disability plus, the other protected classes. And so I am in the camp of you've gotta start somewhere. I guess I would also encourage the folks from the administration who are listening to think about the kind of revisit and rewrite at some points. But recognizing that the scope of this task force is, specific to disability. Because I think Connor is kind of a mess. The second thing I just wanted to say is I just put up some of the materials around the EEOC discussion, and from just my quick scan of those, it's my understanding or my interpretation that that relationship with EEOC is a contract and can be renegotiated. And I think that is a conversation that was had in the subcommittee. So just wanted to raise that.
Thank you. I will never cut off discussion. I am reading the room and seeing folks in some distinct positions. Is there anyone who believes that their position may shift by further discussion, or should we go to a vote? Before I take any vote, I do want to emphasize we have had overwhelmingly unanimous votes up until this point. That doesn't mean obviously that's expected all the time. I do also want to be very clear. Any vote where we have dissenting opinion, those who vote in the minority, you are welcome to provide statements to be included with the report, and we will provide brief commentary without editorializing on any of it. With that said, I'll go to a roll call vote on the recommendation to remove the requirement to exhaust administrative remedies. Mr. Ortiz,
Yes.
Ms. Moran,
I need a couple minutes, Berg.
I will come back to you.
Thank you.
Ms. Jorgensen,
Yes.
Ms. Harpole,
No.
Ms. Beck,
No.
Ms. Moran,
No.
by a vote of 3-2, the recommendation does not advance. I'll move us to recommendation 2, to standardize the statute of limitation for filing claims at 3 years. Problem identified under current law allows filing deadlines after the alleged incident of 300 days for employment, 1 year for housing, and 60 days for public accommodations. The division is statutorily required to complete an investigation within 450 days. Therefore, today's deadlines for completion may take up to 750 days for filing and investigating employment discrimination cases. Housing discrimination may take 815 days, and public accommodation may take 510 days. The recommendation of the subcommittee, passed by a vote of 7-1, is to amend Colorado revised statutes relating to the timeline or statute of limitations to 3 years for any claim of discrimination by an individual with a disability relating to housing, employment, or by and against a public entity or relating to a public accommodation. Note, the subcommittee discussions focus on the rights of individuals with disabilities while noting the different types of claims in Part 6 versus Part 8. It is the intention of the subcommittee in this idea to standardize timelines and rights across all types of claims, including Parts 6 and 8. With that, I will open it up. Pardon me, before I open the discussion, this is the other place where we do have a written comment from CCRD that reads as follows. This change would cause a lack of shared jurisdiction with the EEOC. The lack of shared jurisdiction eliminates any federal funding the state would receive from the federal government. Current law allows filing deadlines after the alleged incident of 300 days for employment, which is aligned with federal employment discrimination laws, 1 year for housing, and 60 days for public accommodations. The division is statutorily required to complete an investigation within 450 days. Therefore, today's deadlines for completion may take up to 750 days for filing and investigating employment discrimination cases. Housing discrimination may take 815 days, and public accommodation may take 510 days. The expansion of filing times will likely lead to large increases in case filings and would require additional substantial resources to meet our mandate. With that, I will open it up to the executive committee for discussion of the recommendation to standardize the statute of limitation for filing all claims at 3 years. I feel like maybe I took all of the energy in that last discussion. We're just getting started, folks. So Hillary, I'll go to you and then to Kirsten.
Yeah, so I'm in support of this, and I am skeptical that increasing the deadline or some of these and making them the same is gonna increase cases by that much. I think there's just like a lot of factors that come into play when people decide to bring complaints, and none of those is having an attorney, and there are not enough attorneys to go around. I also hear the EEOC concerns, but again, I think that could be renegotiated, like in the contract. At least that's my understanding from the subcommittee discussion documents. So.
Thank you, Hillary. Let me go to Kirsten, then Jennifer, and then Elizabeth.
Yeah, I think, well, one comment on the timelines that we've heard around, 750 days or 450, all these other things. Like, one thing I just want to highlight, this is how long litigation takes. Just so that we're clear, I have a number of matters that I'm dealing with right now that are 3 and 4-year-old matters. That's just how litigation works. So I just want to put that one out there. I know we sometimes can hear dates. That's how these processes do go. I think one of the other things I have a really hard time with is, you know, you were discriminated against or you weren't, right? So to have all this additional time, what I'm concerned about is, I'm concerned about the effect that that's going to have on business when it comes to insurance, because I deal with this all the time. All of this stuff and how these expansions and extra time that would go along there, it just means that you have potential exposure and coverage for more periods of time, which is only going to cost businesses more. And back to the point, if someone discriminated against you, you know that that happened. So to have the ability to sit around for 3 years, I just don't think that that is an appropriate time, or just to extend the extra time that goes along with it. And also, memories get really old. So to have something really, really late after the fact, people could have gone. No one may know those facts anymore or really remember what's going on. So I have a really hard time expanding any statute of limitations.
Thank you for the comment, Kirsten. Jennifer, and then Elizabeth.
Thank you, Jennifer Harpole. Along those same lines, I mean, this proposal triples the statute of limitations or more for each of these claims. And I don't think I think the recommendation seems to conflate the time it takes to investigate with the time you have to file the charge or the claim. So those are two different things, right? The longest time right now, the longest statute of limitations right now is 1 year. And I understand the desire to have those be consistent, but then make them consistent at 1 year. I've never, I've not seen it ever be an issue in a case that someone wasn't able to file their claim within a year. I agree that, there's no reason that within 365 days of thinking that you are discriminated against, that you could file a claim. And so it does make it much harder to defend against a claim if it's 3 years later and you're trying to piece together witnesses and documents, and there's turnover in the company, and a lot of times there's changes in electronic systems and you can't go back that far and get data. So I think it does create a lot of challenges for employers that are really not necessary, because I haven't heard any compelling reason why this couldn't be filed within a year. Thank you.
Thank you, Jennifer. Before I go to Elizabeth, and Jennifer, I don't know that this was your intention. I do want to emphasize, as Representative Ortiz highlighted yesterday, this executive committee is not in any way limited by the recommendations you received from the subcommittees. You can take them, you can leave them, you can make recommendations of your own. Jennifer, I don't know that that was your intention, but it is an option for this executive committee to put forward an alternative recommendation, whether that's a year, 5 years, 5 days. So I want to make sure nobody feels limited by what you've received. But Elizabeth, let me go to you.
Yeah, Barrick, with that in mind and with that lens, I'm now second guessing my previous vote and thinking I should have proposed an amendment to that because I was very torn. But that's a whole nother topic, and maybe and let me chew on that, and I might come back to that on this one. So I am in favor of this, and let me tell you why. One of the things we discuss regularly, particularly for individuals who have an intellectual and developmental disability, a traumatic brain injury, who are experiencing any kind of a cognitive or a communication challenge. Often, those same individuals don't have the supports in place that would provide opportunity for them to recognize that I've experienced something that has been discriminatory, or have the supports necessary to effectively communicate what has happened to them, acquire an attorney, and then also provide effective communication supports within that context to ensure that they are able to participate or engage in a meaningful way in due process around that discriminatory thing that happened to them. And so while I appreciate that cases take a long time sometimes, and I appreciate that some of the discussion ahead of me today around changeover in staff and what have you. I think that works both ways because evidence of discrimination, in my experience, the longer the time period, is harder to prove and or defend for both parties involved, but particularly for individuals who have disabilities who, I'm just thinking of clients I've had in the past, and I'm thinking of my own sister, who may not recognize what they've experienced as discrimination until a later date, when they've been talking about it perhaps with a case manager or someone else and saying, well, this is my experience, this is what happened, and someone says to them, you were discriminated against based on your disability, and you were not provided the required reasonable accommodations, and that person may not even fully appreciate what that means without getting some support in place, some effective communication support. So I tell you all of that just to put a little bit of a different lens on it for this group to consider. I think, and I will just tell you that one of the things that as supports, particularly for effective communication, more time to do something and more supports for that effective communication and that meaningful engagement and due process to take place is a regularly used and recognized ADA accommodation to provide that more time. So I just want to put that out there. And again, I am in favor of this recommendation. Thank you.
Thank you, Elizabeth. And I don't want to lose your comment about our previous discussion on administrative remedies. I've made a note in my continuing notes that you may want to offer an amended version or an alternative proposal. And before this executive committee concludes our work as a whole, we will revisit that if you'd like to propose something.
Thank you. I would appreciate that. And yes, I would. Thank you.
Okay. Let me go to Hillary, and then I think Kirsten has her hand back up. Hillary.
Yeah, I think Miss Malaya actually made a lot of the points I was going to make. I just also want to push back on the notion that people know and they've been discriminated against. I think some people do, but I think a lot of people don't. Either the discrimination itself causes some kind of crisis, and people are not able to, get it together enough, file a complaint or whatnot until that crisis has passed. And that being said, I'm not necessarily married to 3 years, and I'm wondering if we can come to an agreement on a timeline that's between like 1 and 3 years. And I also I think the timeline needs to be aligned, because I think it's super confusing and doesn't make sense to me why I mean, it does make, I know how it happened, but like, it should be the same kinds of claims.
Hillary, I don't want to pick the number that sits between 12 and 36, so I will let you, if you'd like to, and I'm smiling with you because a couple of folks have suggested maybe 3 years isn't the number that folks are comfortable with, but maybe there is one. Is there something you would like to propose for the executive committee to consider a vote on?
I mean, how do people feel about 2 years? That's in the middle. I don't litigate these issues on a regular basis, so, I'd love to, if folks who litigate these issues on a regular basis, hear from you, if that feels better to you. And Elizabeth would like to hear from you too, you think too, if a place we can maybe meet in the middle.
Let me, if I could, this is one of the places where I'm going to start pulling folks in. Elizabeth, I'd love your thoughts. And then some of the folks, Jennifer and Kirsten, who had concerns about this, does your view shift at all if the consideration is a different timeline? Elizabeth, your thoughts?
Not necessarily. Hillary, can you just speak a little bit? So how would it read if you were rewriting it? How would it read?
Then instead of a 3-year timeline, it would be a 2-year timeline.
Oh, say that one more time for me.
Instead of a 3-year timeline, it would be a 2-year timeline.
So we would just, in that first line, strike 3, and it would instead read amend CRS relating to the timeline or statute of limitations to 2 years for any claim of discrimination by an individual with a disability relating to housing, employment, or by and against a public entity or public accommodation.
Yeah, I would still support that. Thank you.
Jennifer, I'm going to put you on the spot because you had thoughts here, and then Kirsten, I'm going to ask you as well.
I would support 1 year. I'm on the fence right now about 2 years.
I'm exactly the same. I'd support 1 year. 2 years is just too long. And I understand that you need additional supports. But it's a year of time. Someone can go and get someone to assist them with this process. And again, I just go back to, I know the impact that this is going to have on businesses to expand these. And that is the unintended consequence that I think I'm really concerned about protecting against.
So members, this is where I do put it back in your hands. We had it drafted as 3. We had a soft suggestion that I wouldn't say it was a formal proposal for 2. We had others who suggested 1. If you'd like, we can vote on both the 2-year and see if you have consensus, or you can continue the discussion and see if you can find broader consensus in the group. Is there anybody who would like to bring either 2-year, 3-year, or 1 year to a vote? Representative Ortiz.
Well, if they're going, first of all, I want to see how Hillary and Elizabeth feel about the 1 year. I just don't think that's enough time. And
I don't.
Again, I hear, oh, that's plenty of time. Who's saying that? The completely able-bodied folks that don't work with disabled folks? They're the ones that are completely saying that, right? Like, that's cool. And like, that's the whole point of this task force, is enough access or enough time according to who. When completely able-bodied folks say it's okay or say that it's enough. So if Hillary and Elizabeth are not okay with 1, and Kirsten and everybody else is not okay with 2, then I say let's just go for 3 and let the legislature hash it out. Then give them extra to negotiate with when they bring the bill forward. So like if compromising isn't going to get us anything, let's just pass it with the 3 years, and we will allow the legislature to negotiate the details, giving them more.
Message heard, and Elizabeth did say she would not be comfortable with the 1 year. Let me go to Hillary and then Jennifer. Unless you tell me differently, I've got a proposal from Mr. Ortiz to continue with a vote as the recommendation was brought to you.
Yes, I'm less comfortable with 1 year. A lot of times these forms of discrimination cause a crisis in someone's life. Like, housing discrimination often, causes someone to become unhoused. And often they have to deal with the crisis in front of them before they can get to a place where, they can consider filing, any kind of complaints. I also just want to raise, I think one of the things that's gotten lost in this discussion is, I think part of the reason this discussion came up in the first place is because the public accommodation timeline is so much shorter than the others. And, that is like one of my big concerns is that we lengthen the public accommodation timeline.
Jennifer and then Elizabeth.
Thanks, Jennifer Harpole. Yeah, I appreciate Representative Ortiz's kind of, assessment of the room in general and all of us, right? So, in the spirit of compromise, I would say that if we can do a 2-year proposal, then I could back that.
Elizabeth.
Thanks, Barrick. So the longer I'm thinking about this, the more I'm in favor of a 3-year. So, I just did sort of some research really quick. It's my understanding that civil actions, such as like breach of contract, fraud, misrepresentation, breach of trust, et cetera, that's a 3-year statute of limitation.
Yeah,
Am I-
that's right. But personal injury is 2 years. So there's an inconsistency between the two. And here's where I'm concerned. A breach of contract does not fall under your insurance claims, right? That's not when I go renew as an employer my insurance claims. They don't really care about my breach of contract claims. They care about all of these other injury, discrimination, everything else. So to have a 3-year statute of limitations, what this is going to do for the business community, I mean, it's just not good. That is just way too long. There is way too much of an impact, I think, that it would provide and leave on the table as far as liability, that our businesses right now are already having a really difficult time. Colorado went from being one of the top business environments in the country to one of the worst just over the last 10 years. So I adamantly think that 3 years is far too long. And I think 2 years is too. You need to know what it is that you have as far as claims.
So Kirsten, I don't want to put words in your mouth, although you may have come close. Is it my understanding you would be no more supportive of a 2-year proposal than of a 3-year?
That's exactly right.
Thank you. Representative Ortiz, I saw your hand go up and then down. Did you want to jump in?
You asked my question for me.
We have a recommendation from the subcommittee in front of us. I think we have pretty clear positions from members. Unless someone tells me you have an alternative proposal, I'm going to go to a roll call vote on the recommendation as advanced by the subcommittee to standardize at 3 years. Before I do that, does anyone want to put a formal proposal on the table for an alternative vote? Seeing and hearing none, we will go to a roll call vote. Representative Ortiz,
Yes.
Ms. Moran,
Yes.
Ms. Jorgensen,
Yes.
Ms. Harpole,
No.
Ms. Beck.
No.
By a vote of 3-2 of the members present, which does constitute a quorum, the recommendation does advance. Ms. Harpole and Ms. Beck, as I said to others on the previous recommendation, if there is specific language or general language you'd like included in the report as to the basis and the rationale for dissent, I'm happy to include that. We are going to go to one more recommendation before I give the promised break I offer in all of our extended meetings. And if this next discussion becomes extended, we'll take a break in the middle of it. But the recommendation is to allow recovery of emotional distress damages. I think the problem to solve here is important, particularly the legal background on this. And that is that in 2022 Supreme Court case of Cummings versus Premier Rehab, the court ruled that people who experience disability-based discrimination cannot recover emotional distress damages from public and private entities that receive federal funding. The Cummings decision eliminated the ability of people who experience disability-based intentional discrimination to obtain emotional distress damages from public and private entities who receive federal financial assistance from the federal government under Section 504 of the Rehabilitation Act of 1973 or Section 1557 of the Patient Protection and Affordable Care Act. As a result of the decision, entities such as public and private colleges and universities, hospitals, group homes, physical therapist office, and others who receive federal financial assistance, including federal grants, loans, or other forms of federal financial assistance, no longer need to remedy discrimination based on disability when the only harm of the discrimination results in anxiety, stress, depression, marital strain, humiliation, or other similar emotional pain. The subcommittee seeks an end state in which there is a legal means for an individual who's been discriminated against based on their disability by a government agency or public business to seek and recover damages for emotional distress. The subcommittee therefore recommends to the executive committee that we amend Colorado revised statutes to allow an individual with a disability who has been discriminated against by a government agency or public business to pursue emotional distress damages. The above change would be through a revision of CRS 2434-802 and elsewhere as necessary. Important note, the idea being considered here does not speak to the amounts or caps which are contemplated by ideas below that we will further discuss. This idea strictly relates to allowing the pursuit of emotional distress damages against a public entity or excuse me, a government agency or public business. With that, I'll open it up to members of the executive committee for discussion and perspectives. Hillary, you're in.
I am genuinely supportive of this. It's just we're still in something that Cummings, innovated. And sometimes the only damages are non-pecuniary. I think one of the examples that the subcommittee heard was a mother who's missed her son's graduation because of the inaccessible venue. There were no physical damages, right? It was all emotional. But Bill, I have a clarifying question, or maybe a background question. So I can foresee a scenario in which someone may not be supportive of this recommendation unless there are caps. And so I'm wondering if there's some background on why the subcommittee chose to break these into two instead of combining them into one.
They wanted to provide you're hitting on what was months of discussions, Hillary.
Yeah.
And they explored multiple structures and tables and tiers of damages. They looked at how other damages are assessed based on employer size. They had discussions about recommending everything from putting tiered damages related to the gross revenues, the net earnings, the employer size, the head count of different employers. They wanted to separate this and put it in your all hands. I think everyone is aware on the subcommittee, for anybody listening to the stream, the next idea we will be discussing is a proposal to set no caps on the amounts of these damages. This is where I will remind you that you can advance that recommendation, or you can choose to put forward the idea of allowing the emotional distress damages, but rather than advancing the recommendation as is for unlimited or no caps, you could put in some structure of caps. But Hillary, the shorter answer is they had so much back and forth about it, they decided to put it in your lap.
At the risk of opening up Pandora's box, because I do think allowing emotional distress damages is really important. I am also a pragmatist, and I think me personally and my organization have always assumed that this would go hand in hand with some kind of cap. Because you can't just create unknown liability for the states and, private sector as well. And so I don't know. I'm wondering how people might feel about curtailing maybe some of the discussion on note caps, because my guess is that's probably a non-starter, and see if we want to combine some recommendation for a cap in with this one. And then, I don't know, maybe I'm making things too complicated.
You are absolutely free to do that. Just to inform the discussion, then I'll go to Jennifer and then Representative Ortiz. The next recommendation is short, and it says amend CRS and set no cap or limit on the amount of damages that could be awarded. So you are certainly free to address these separately. You're certainly free to say we don't want to take a vote on them separately, and we instead want to put forward a combined alternative recommendation. It's very much in your hands. I want to be very clear about that. Jennifer.
Thank you, Jennifer Harpel. Hillary, I think that's a great idea. So thank you for bringing that forward. I would be in support of allowing emotional distress damages on these claims. I mean, I recognize the situation that was described, that brought forth by the committee, and the, in circumstances where those are the only damages, but I agree that those are real damages that should be recoverable. However, as you as you guess, I also would not support no limits, right? That just could result in runaway jury verdicts that are just completely out of proportion to the damages that are caused. So I would be in favor of a cap, and then could agree to allowing emotional distress damages.
So now I'm going to complicate this even further for the group. You have a number of directions you can go. You could choose to put forward a recommendation that allows emotional distress damages and sets a cap, one single number. You could choose to establish a tier with multiple numbers based on factors of your choosing. That could include anything from employer size to net income to the type of the infraction. Or you could say that a cap needs to be set, and the legislature, in establishing those caps, should set multiple tiers or a single tier and should consider a number of factors. So it's up to you of, do you want to set the number? Do you want to set the tiers? Or do you want to direct the legislature within some parameters? Hillary.
So I'm going to be really pragmatic here, knowing that the subcommittee had months of discussion on what a tiered system for damages could look like in a cap, and also knowing that whatever we recommend is probably not going to be adopted vote for vote by the legislature. And so I'm going to be pragmatic and put forth a proposal that we allow non-pecuniary emotional damages, whatever word we want to use, then a tier cap system to be determined by the legislature. I'm not as good at wordsmithing on the fly as you are, Eric, but that is my attempt.
I appreciate it, and I will confess that I had to quickly Google the Lieutenant Governor's comment on non-pecuniary, that is another term for non-financial damages. So, Lieutenant Governor, thank you for teaching me something today. I would welcome the group offering thoughts on this, and I'm happy to offer some language once I hear from you. What factors, if any, do you want to direct the legislature in your recommendation to consider in setting these? And do you want to set any parameters within that? And by that, I mean, do you want to say there must be at least 2 levels, or do you want to say there must be caps that are substantially aligned with other cases of discrimination? Do you want to name things that are included, or do you want to give them latitude that they should consider but not be bound by ideas such as? Representative Ortiz.
Having been on the receiving end of a lot of meetings with individuals from the Judiciary Committee, as a lot of my bills tended to go in front of them, I think it's a discussion that should happen in a bipartisan way. We can try and set some guidance if we feel like it, but I am very loath to, for this item anyways, I'm very loath to set guardrails. We can make recommendations. I would be okay with maybe making soft recommendations. Something that I would also be interested in making sure is that this is not static, meaning that the tiers increase with inflation or with some type of marker every so often, so that future legislators, like, that would be a soft recommendation that would be okay making. And if businesses want some planning latitude, then we can even make the recommendation that it is adjusted every 3 to 5 years, right? I don't know. I know that in a bipartisan way with both Democrats and Republicans, a lot of the most nuanced discussions I've had in that building have been with those on the Judiciary Committee and those that deal with the budget and finance. So I trust them, is what I'm saying.
Thank you, Representative Ortiz. So I could offer to you, we keep the recommendation as is, but add the statement that the legislature should establish caps on such damages that are adjusted on an appropriate periodic basis of not less than every 5 years. That would leave all of the other discretion to the legislature. How does that sit with members of the executive committee? Jennifer.
Jennifer Harpel, Beric, I think so Hillary had mentioned tiers specifically. So I think the one thing that wasn't in what you just said was tiered recommendation, which I would be in favor of some sort of tiering, whether it's based on, you asked us what to base it on, right? And I think we'll defer to them on what they want to base it on, whether it's size or income or what have you, but some kind of tiered caps.
How about if we simply were to say the legislature should establish tiered caps on such damages that are adjusted on an appropriate periodic basis of not less than every 5 years? Okay, with these adjustments then, the recommendation would read as follows. Amend Colorado revised statutes to allow an individual with a disability who has been discriminated against by a government agency or public business to pursue emotional distress damages. The above change would be through a revision to CRS 24-34-802 and elsewhere as necessary. In advancing this change, the legislature should establish tiered caps on such damages that are adjusted on an appropriate periodic basis of not less than every 5 years. Is there anyone who wants to offer further discussion before we go to a roll call vote on this?
I have a question, Beric.
Yes, please.
Just in hearing that, I'm picturing myself being a legislator, hearing all of that and going, I'm not sure what that all means. Will there be an opportunity to provide some sort of commentary or something that will help give context?
Absolutely. At minimum, what I will do is provide a summary of this discussion and the history of the discussions within the subcommittee. I don't know if there's something else that you would like to propose, but I'm happy to make sure that the legislature gets the full picture that you all would like.
Sure, that'd be great. And, as I think as most of us know, when we're doing legislation, too, the commentary is often very helpful in just providing context. So I'm comforted to hear that you'll be providing that.
I will put that together. We will go to a roll call vote on this item then. Representative Ortiz.
Yes.
Ms. Moran.
Yes.
Ms. Jorgensen.
Yes.
Ms. Harpel.
Yes.
Ms. Beck.
No.
By a vote of 4-1, the recommendation to allow emotional distress damages with tiered caps to be established by the legislature and updated not less than every 5 years will advance as a recommendation. I am going to quickly dispose of one item and then give you all a 5-minute break. Our next item, because it came to you and we put it out for survey, does need to get the up or down vote. The item was to amend revised statutes and set no cap or limit on the amount of damages that could be awarded. On the recommendation to set no cap, Representative Ortiz.
Yes.
Ms. Moran.
Yes.
Ms. Jorgensen.
No.
Ms.
No.
Harpel.
No.
Ms. Beck.
No. I think that's a huge mistake.
By a vote of 3-2, the recommendation to set no cap on emotional distress damages does not advance. It is 10:10 a.m. We will reconvene at 10:15 promptly to continue going through the remainder of the recommendations. For any members hiding off camera, it is 10:15. We're going to get started here in the next minute. Members, it is 10:16. If you're at your computer and just waiting for that moment to turn your camera back on, would love to get you back so we can continue going through the recommendations.
I'm here. Let's go.
Thank you, Representative Ortiz. We will go ahead and continue. Our next recommendation is one of the final ones related to the emotional distress damages. It reads as follows. Amend Colorado revised statutes as contemplated above and further amend to allow plaintiffs to seek and recover additional punitive damages if affirmative intent to violate the underlying statute is proven to the appropriate standard by the plaintiff. Would anyone like to begin the discussion on this item? And just by way of background, the problem the group was looking at was that Colorado law currently does not provide a right to seek punitive damages in these types of cases. Is there anyone who would like to offer a thought of support, opposition, or consideration? Mr. Ortiz.
I mean, my thinking is that would be a very high bar, but it still should be an option. I mean, if someone is trying, like if that can be proven that someone was actively and maliciously trying to discriminate you and take away your basic access and your basic rights, then, you know, that should be an option. But I know that's a high bar to prove. So for any of those that might be worried that that might be opening a can of worms, I don't see it as such. It just provides more assurances and securities in the case that someone is out there maliciously trying to discriminate against the community living with a disability.
Hillary.
Yeah, thanks. I have a similar thought. I am conceptually in favor of this. I am in favor of this concept, I should say. But I don't know how much like real world impact it will actually have because that bill is pretty high. But I do think in cases where it can be proven, like the damages should be available.
Thank you, Hillary. Any other member thoughts on this one?
I just struggle with punitive damages. It would have to be an unbelievably incredible bar. It just kind of comes back to the threat of these could be what takes businesses down, even if they weren't actually intentionally doing anything. That's the concern that I have. Is it could get very, very costly, particularly if it was a entity that wasn't actually doing anything.
Kirsten, and I'm not trying to sway discussions in any direction. Is there language that you would want to see in there to provide that protection, or is it simply an idea
No.
that you can't
I
support?
struggle with it overall because here's
Okay.
the thing, every attorney kitchen sinks it, right? So I think the hard part that a lot of folks are on, and obviously this is why we all are on this committee, is we have very different perspectives and we come from very different perspectives. And I recognize my perspective is very different, which is why I'm here. And because of that, every single time, the amount of times that I hear people say to us, well, we're just going to sue you. We're just going to sue you. And these are things that have nothing to do with us being bad actors, intentionally discriminating, anything else that goes along with it. It's just someone's upset for whatever reason. And if I told you some of the stories that have happened of things that we've had to deal with, you would understand why my perspective is the way that it is. And so everyone is going to kitchen sink this stuff, even if there isn't that really bad actor. And the problem I come back to again is that then it can be a real problem for the business community to be able to move forward. Punitive damages are not winners. I mean, in every single contract I write in, we write those things out because that can crush and ruin an entire matter. So I just have a really hard time with it, because I get it that for the really intentional, horrible actor, this would be appropriate. But the problem is it's going to be used against 99 unintentional actors, and it's going to cause a problem that way.
Understood. Thank you. Jennifer.
Thank you, Jennifer Harpole. Yeah, I have similar concerns, which is just that it's going to vastly drive up settlement value of cases, right? That those are the threat of punitive damages is just going to be able to be wielded over the head of employers to extort higher payments from them. So I am not in favor of adding punitive damages. I think, the other available sources of damages and the ability to recover attorney's fees, which all already exist in the statute, are sufficient.
Thank you, Jennifer. So far, I'm hearing two distinct views. One, that this is a high bar that should be permitted. Another view that this creates a risk because of potential filings of cases. Is there anyone who would like to offer thoughts for your colleagues to hear, or would like to ask your colleagues a thought that may inform your vote on this?
I'd like to offer one thing, which is I think if we want to get support for this moving forward and get support for a lot of the recommendations that are around here, types and provisions like this are going to be the non-starters, where you're going to turn off the business community completely, and they're not going to even want to have a rational discussion about certain items that are appropriate for us to be dealing with and addressing in this legislation. So that's my concern, is that this one, to me, is enough of a hammer that you're going to completely have the business community on the opposite side of the room and not even wanting to have a discussion about any of the other recommendations, which I think we've done some really great recommendations. Obviously, I voted yes on a lot of them. So that's where I would be concerned. And you hear things like this, and this is going to get people right on their hackles. This is the right place where you're going to do it.
Thank you for sharing that perspective, Kirsten. Others? Hillary.
I guess I was trying to think it could be like a middle compromise proposal, and I just don't know that there is one. So I think you either have punitive damages or you don't, and then you create the standard for, proving the discrimination necessary to receive those damages. And I am not unsympathetic to the arguments about, the threat of this being used against businesses and potentially the states. But, and this is an ongoing theme, I feel like anyone who has had any discussion related to any kind of damages about anything in the last decade has had. I think a lot of the concerns have little to do with the way our legal system is structured, which is not in the purview of this task force. And so I think, because of the scope of this task force, have to focus on what our challenge is. And I think, potentially maybe there should be some reform and, how legal practice in general looks on the civil side of things. But I feel like that's not the purview of this task force.
Hillary, I appreciate that. I also want to call out for the group that whether you advance a recommendation or do not advance a recommendation, any of these framing thoughts and notes or additional thoughts that you'd like to share in the report, I welcome them. For example, if you want to name, we voted for or against this, notwithstanding that vote, we believe there are broader issues that the state should continue to address that are outside the scope of this task force. We welcome those that narrative being included in the report. With that, and not seeing a lot of movement of folks, I'm going to go ahead and go to a roll call vote to allow punitive damages. Mr. Ortiz.
Elizabeth had her hand up, so if we could delay the vote.
I apologize.
Okay,
Thank you for catching that for me. Yeah,
That's okay. Thank you. I'm wondering if the group would I'm just playing with the language a tiny bit to remove the word additional and affirmative, so it would read amend CRS as contemplated in item 1 above, and further amend to allow plaintiffs to seek and recover punitive damages if gross negligence or intent to violate the underlying, the rest remain the same.
I personally would not. And again, it comes back to, it's the pile on. Every time there's an issue, and it could be, again, I'm talking about, I understand when we have a bad actor. The hard part is that you're going to throw in all of the good actors or unintentional folks who just something happened and they need to address that, which obviously we have provisions for, and we need to address that to begin with. I'm just really concerned, back to Jennifer's point on it's going to drive up how much your settlement is, everything else that goes along with it, and it just is going to drive out business. Punitive damages are not a positive thing in the business community, and it's really, really difficult to get insurance if you have those kinds of things lingering.
Appreciate the direct conversation back and forth. Representative Ortiz.
Yeah, and I mean, it sounds like no matter what we put in this language, that's and that's the prerogative, are not going to be moved by it. I think what I'd be more comfortable with then in that case is to give context and say this really should be a high bar. Like this should be like if someone is out there kicking over people in wheelchairs and using language like, and excuse my French, but I'm just trying to set up an example of a very high bar. Fuck that cripple. Like they should be subject to those punitive damages. Like, and if that is provable and recorded, there should be a means by which someone like that is subject to that kind of justice. It sounds like to some, no matter what we put in here, it's not going to be okay. I then don't want to be specific about recommendations. What I'd feel more comfortable with is giving context that state that the intent is to create a high bar that allows for justice in those cases against individuals with malicious intent, obviously provable and malicious intent. And let the debate happen in the legislature. But that's just my thinking. If other members of the committee feel differently, I'm open to that.
Hey, Barrick, you're still on mute.
Thank you very much. Representative Ortiz, I'm going to offer a sentence speaking to what you just shared, then I'm going to read the Lieutenant Governor's comment. Then Jennifer, I'll come to you. We could, consistent with what Representative Ortiz is discussing, add a sentence that says something along the lines of, in advancing this recommendation, the executive committee urges the legislature to set a clear and appropriately high bar for recovery of punitive damages where there is clear and malicious intent. The lieutenant governor also weighed in on the chat that there could be caps similar to the process that we had in recommendation 3 relating to allowing the emotional distress damages, or include a punitive factor for intentional discrimination in that calculation of the emotional distress damages. With that on the table, Jennifer, I'll go to you, and then I'll continue to open it up to the executive committee members.
Thank you. Yeah, I appreciate Elizabeth, you trying to offer a compromise. I do think this is an area where I'm just not gonna be able to get on board with any type of punitive damages. So we agree that probably further discussion on that specifically is not going to be productive. Thanks.
That being the case, and certainly respecting all members' rights to have these, and the lieutenant governor notes that in housing cases, the penalty goes up for entities that have other recent violations. Mr. Ortiz, do you want to consider a vote with the additional language building on what you had offered about setting clear and appropriately high bar for the recovery of these damages? Does anyone want to build on the lieutenant governor's notes about setting either tiered caps, as we did with emotional distress, or about incorporating them directly into those, particularly where there's repeat offenders? Elizabeth, jump in.
I just want to say that I very much like including a punitive factor for intentional discrimination.
Yeah, and when it comes to the recommendation of caps, that's something that could be debated. I think the point is that this should be such a high bar and saved for the most extreme cases that I would trust the discretion of the judge at that point, like we do in so many things when it comes to our judicial system.
Thank you, Jennifer. I have appreciated you being here. We'll see you on Monday, I hope. So with that, Representative Ortiz, do you want to move forward with the additional language that the executive committee urges the legislature to set that clear and appropriately high bar for recovery of punitive damages where there is intentional discrimination?
I guess I would ask the opinion and input specifically from Elizabeth Moran and Hillary Jorgensen on that, and see where they land on that.
Thank you.
I'll defer to Hillary. I've been talking a lot.
Yeah, I'm fine with that. It should be a high bar. Yeah.
Then we will go to a roll call vote to allow plaintiffs to seek and recover punitive damages if affirmative intent to violate the underlying statute is proven to the appropriate standard by plaintiff, with the executive committee urging the legislature to set a clear and appropriately high bar for the recovery of punitive damages where there is intentional discrimination. Mr. Ortiz?
Yes.
Ms. Moran?
Yes.
Ms. Jorgensen?
Yes.
We just lost Ms. Harpole. Ms. Beck?
No.
By a vote to 3-1.
I'm sorry to interrupt. I don't know that this is allowed, but Jennifer did put in the notes that she wanted to be recorded as a no. I don't know if that's possible, but I just want to find that.
We are not bound by strict Roberts rules, and we have not established proxy or attendance. In that vote was recorded prior to her departure before we made any further changes. Unless someone else objects, I will record that as a duly received no vote.
I'm okay with that.
Thank you. We're going to move into public accommodations. We've got a group of discussions that all stem from what I think people may be familiar with, the Chevron deference case and some of the changes that resulted from it. I think the short version is in Natural Resource Defense Council versus Chevron, a 1984 case. The courts ruled in what has been established and referred to as Chevron deference that in a case of litigation where legislation, and it speaks to federal legislation, is ambiguous or leaves the interpretation or leaves administrative gaps, the courts must defer under that 1984 ruling to the regulatory agency's interpretation if the interpretation is reasonable. In 2024, Chevron deference was overturned in the Loper-Bright versus Raimondo case, which then allowed judges to utilize their own judgment to determine if the regulations enacted by an agency are a reasonable interpretation of the law. So we've got a group of recommendations from the Rewrite Committee that relate to the change since Chevron deference was overturned. The first one relates to incorporating DOJ and DOT regulations directly into Colorado law. And again, the group identified that the 2024 Loper Bright versus Raimondo, the court ruled 6-2 to overturn the 40-year-old Chevron deference doctrine. Court ruled that courts must independently decide if an agency has acted within its statutory authority, which could place into question the legal weight of regulations promulgated by an agency to enforce a law. The details of many anti-discrimination protections, such as door width, are established in regulation rather than in law. So the subcommittee has recommended that Colorado incorporate the 2010 Department of Justice ADA standards for universal design and the Department of Transportation ADA regulations into Colorado law by direct incorporation rather than by reference. For additional context on that, the subcommittee's discussions focused around those regulations being overturned or changed in light of the Loper Bright decision. Would anyone like to offer discussion or perspective on the recommendation to incorporate the 2010 DOJ ADA standards and the DOT ADA regulations into Colorado law? Or does anyone have questions, since we're talking a lot of legal cases back and forth here? Hillary.
I don't have a question necessarily, but comments. So I 100% understand the thought process behind this recommendation. I think one of the things that is difficult is putting regulation into statutes, because regulations are designed to be more flexible. And as like technology changes and things like that, then you have to go back and change a statute. And I'm wondering, instead of putting the regulations into statute word for word, if we maybe I'm opening Pandora's box here, but if we could recommend that the legislature direct the appropriate agencies to adopt rules, I mean, I don't know, then I guess you don't have a guarantee that you get the same rules. I'm just struggling a little bit with how this like functionally look. But I totally understand the impetus there, and I agree with the spirit. I'm just trying to figure out a way to wordsmith this one so it might look.
Representative Ortiz.
Yeah, but I think if we want to wordsmith it, definitely open to that. But we do put best practices and regulations in a state statute. In fact, I ran a bill for those youths that are involved in the criminal justice system that are staying in state-run institutions, that we created essentially a Bill of Rights for them, and that was based on 5 years of best practices of the current existing executive director and administration. And the reason why they wanted to put that in the state statute is because those were proven best practices, and it has caused better outcomes, and they don't want those to be stripped and dependent upon the whims of the next person to come in as director. So I hear the concerns, but I also know, one, that we as the state legislature have done this before, and two, that it is valid and useful in protecting the rights of certain individuals. But I'm always open to wordsmithing if that's what we want to do here.
Kirsten.
I'm totally, I'm assuming that people are supportive of these referenced regulations. I personally think it's an incredibly good idea, if those are the rules and the regulations that we like, that you would put it in that statute to protect and ensure that a future judge doesn't come in and decide that they're going to come up with something different, right? I mean, that's what Chevron really did, is it took away the authority of really the people who are the experts and put it in the hands of a judge who we already know is not the expert in whatever subject matter is coming in front of them. So I definitely think if this, assuming those are the rules that we all are comfortable with, then it is a very good idea to go ahead and put it into the statute to ensure that they actually stay in place.
Thank you, Kirsten. Elizabeth.
I agree with everything that Kirsten just said, and I appreciate her. I too am in support of this. I think it provides equal protection under state law, and it eliminates confusion about where do I file a federal claim versus a state claim versus a right. And it provides, to me, it basically just takes what we know to be law for over 35 years now and puts it into state practice and says, yes, it's a federal law, but it's also incorporated herein in our state law too, so that state courts can handle this.
Hillary, having heard from your colleagues, do you have additional thoughts?
I'm slowly becoming convinced, and maybe it is a lot of work to update state statute, but maybe that's what we have to do in order to offer equal protection. And yeah, maybe that's just the process we have to go through. So I've changed my mind based on the conversation.
Then, seeing no objection, I'm going to go ahead and go to a roll call vote on the recommendation to incorporate the 2010 DOJ ADA standards and the DOT ADA regulations into Colorado law. Mr. Ortiz,
Yes.
Ms. Moran,
Yes?
Ms. Jorgensen,
Yes.
Ms. Beck.
Yes.
Thank you all. Continuing on the theme of the Chevron deference, the next recommendation, based on the same challenge created by the Loper Bright decision, the group recommends that the state this is a little different, examine and consider incorporating into Colorado law the U.S. Department of Justice Title I regulations relating to the EEOC. Does anyone have discussion on this item?
Barrick, what was the vote on this from the subcommittee?
The vote on this was 6-1.
Thanks.
I have the same view here. I candidly am not familiar enough with the rules that you just cited I'm assuming we're all comfortable with those and that those are good standards. With that assumption, again, if we want to make sure that an activist judge down the road doesn't decide that they know better than everyone else and what our experts and our agencies already have done and been practicing for however long, then I think we absolutely want to include it.
Does anyone have concerns or views in opposition to the recommendation to incorporate, to examine and consider incorporating the EEOC? We will then go to a roll call vote. Mr. Ortiz,
Yes.
Ms. Moran,
Yes?
Ms. Jorgensen,
Yes.
Ms. Beck.
Yes.
Our final item relating to Chevron is a little further reaching. Again, the problem relates to the overturning of the 1984 Chevron versus National Resource Defense Council and the shifting of the authority to the courts to determine and utilize their judgment whether an administrative agency's regulations were consistent with the intent of the law. The group wanted to create an end state in which Colorado law, establishing in Colorado law the enforceability of and deference that must be given to regulations promulgated to implement or enforce a duly passed law by an appropriate authorized agency. Their recommendation is to codify into Colorado law the judicial deference established by Chevron versus Natural Resource Defense Council prior to the Loper Bright case to direct judges to give deference to the regulations or rules adopted by a government agency to implement a law if those regulations can be reasonably seen to be consistent with the law. Mr. Ortiz.
I feel like, and Hillary, correct me if I'm wrong, I don't want to speak for you, but I feel like this gives this would give the flexibility that we're seeking given the current state that we're in. Yes or no? Yep. Okay, great. Then I'm in high support of this.
Any discussion on the recommendation to incorporate into Colorado law the deference previously existing in the Chevron deference case? We will then go to a roll call vote. Mr. Ortiz,
Yes.
Ms. Moran,
Yes.
Ms. Jorgensen,
Yes.
Ms. Beck.
Yes.
Okay. Now we move in a significantly different direction. We go back to CAPS. We previously discussed CAPS strictly as it related to emotional distress cases. The group looked at others and said that there are existing and varying caps or limits set on the amount of damages a plaintiff can recover in different claims for discrimination. They recommended that we increase the amount of damages that could be recovered for discrimination claims. Specifically, their recommendation that comes to you with a vote of 6-1 is to revise Colorado's revised statutes that incorporate caps established for damages by the ADA 1991 to remove all limits on damages for discrimination in cases of housing, employment, or access to a public entity or place of public accommodation. They include a note that juries are not informed of the caps during trial or deliberations. I'll open it to discussion of the executive committee.
I'm happy to go here. I think this is a really bad idea. I've been pretty clear about caps already and where my concerns are when it comes to liability, and I'm definitely not in support of this.
Hillary.
So I'm conflicted about this one because on the one hand, I think the vast majority of damages under these kinds of cases are not that high. We have the other team who litigates these kinds of cases on a regular basis, and I think their average of bill is like $100,000 or something like that. So, juries are not, carrying violent out here for the most part. But where I am conflicted is particularly on the state side, because of Colorado's unique financial situation, having to underwrite that amount of risk without a cap, I feel will have state budget implications. And in a year like this, not everybody looking at, cuts to essential programs like Medicaid and K-12 education. And so, not that I don't care about the private sector, but I just have a lot of concern around, the state having to underwrite, unknown risk, essentially. I know that the state has a risk fund, and they sometimes have to pay general fund out, the new laws are passed. So, yeah, I'm really, really conflicted about this one, and I think where I'm leaning is, I would support maybe like a high cap or like a tier cap or like, maybe a cap on government, but maybe not on, I don't know, but then like, the Department of Corrections often has lots of really legitimate cases and want those people to be able to recover. I'm sorry, now I'm just like thinking out loud. I'll stop. But
No,
that's
I
where
welcome
I am. That's where I am right now on this recommendation.
it. And if this is one we need to continue, we will. Let me go to Kirsten and then Rep Ortiz.
Yeah, I have one comment. I know I've said a few things about insurance, and I really want to hit this home so that we all understand kind of the impact of where this is created. And I'm going to use a different example, but I'm going to use in HOAs and in condos. If all of us are familiar with Colorado's housing market, our biggest problem is we have the smallest condo market in the country for a metropolitan area. And the reason why is because of our construction defect litigation issues. We did not have caps on litigation for construction defects for years. And that is why we are still sitting here today, and why it is that all we see are new rental multifamily buildings and we don't see new condo buildings, and why we have a huge gap in our housing market is because of the fact that our home builders are not able to get insurance because of construction defect litigation, because of things like this. So the unintended consequences, and again, I fully appreciate and understand for the bad actors, there's something that we need to do. I think there's also a bigger picture here, because what it happens is a flood of litigation. I know that because I deal with frivolous lawsuits all the time. Everyone wants to go after the big targets, and we waste a lot of money on really bad, frivolous claims. Are there other claims that are legitimate? Absolutely. And those are things that we need to address as part of a business as well. But I really urge you guys to think about, and I should have said this earlier, it didn't occur to me until just now. The condo market is a perfect example of where it is that us, all us Coloradans, are left. And we're left solely because getting insurance is a real problem, and it's because of our lack of construction defect issues. And everyone will then say, well, that builder that did the bad job, we have to be able to go after him. And we've had these exorbitant jury awards and other awards that have gone through it. And what it has resulted in is that we have an insurance market where you can't get it for sale products, or if you do, it's really expensive, which is why there's so few of them. So that's the part I have some real concerns about, and that's where my damages issues always are going to come from.
Thank you, Kirsten. Representative Ortiz and then Ms. Moran.
I'm going to hold my statement to the end. Thanks.
Ms. Moran.
I'm wondering if the committee would be agreeable to, first of all, I appreciate everything that's being said here. And I do think, it's hard. Colorado, we just had some changes go in, 2025 changes go in for caps for non-economic awards. I think it's 1.5 million, if I recall, that just started this month in other cases. And so I'm torn right now. Here's my question, whether or not this committee would be agreeable to at least inserting the word in the second sentence where it says to remove all limits on damages for, and then I would propose we insert the word intentional discrimination. That may not make any difference, but I do think there's a difference between discrimination that is unintentional, that is brought to someone's attention, versus intentional, they knew about it and they just.
I think punitive damages are for intentional discrimination. Like that's we just had that discussion. When it comes to removing caps, I'm curious as to what housing laws that currently exist for Coloradans with disabilities that is creating the fear that I'm hearing behind this characterization of endless lawsuits that are going to come forward. I mean, the bottom line is we're here to solve problems. And 20% of Coloradans live with a disability. Yet less than 1% of housing options are accessible. So do we think that that's just going to change on its own? I'm here to posit that no, that's not going to change on its own. And one of the ways that gets people to change is to be able to litigate and say this is unjust, and to create preemptive behaviors that create access, right? Like the housing defect law, again, I'm going to go back to what Hillary has said, is not the purview of the Disability Rights Task Force. That is not our fault. Communities living with the disabilities fault. That is not our fault. That is not our fight. I want to see, as an individual living in Colorado, I want to see more affordable options. And I look forward to seeing the legislation that President Coleman said he was going to put his full weight behind as his tenure, starting off as president. I look forward to seeing what that is. but it's our job to try and solve a housing crisis for a community with disabilities. Do you think there's a housing crisis now for people here in Colorado? There's always been, and there still is, a critical housing crisis for those of us living with a disability. There was a news story that came out 3 years ago where one group of folks that had one type of disability was kicked out of their living situation and make room for another group, right? Who else does that happen to? So I hear the concerns. I'm okay with pushing this recommendation forward. One, because it passed 6-1 out of the subcommittee, and two, to allow the details then to be debated by the legislature. Like if we want to wordsmith a little bit, I don't want to give too much direction here because I want them to have free reign to explore what this looks like. But the bottom line is, it is our task to solve issues directly relating to the basic human rights and basic access of Coloradans living with a disability. And there is a housing crisis. There's been a housing crisis.
Hillary, I'll bring you in. I want to know, I received a direct message, someone asking, could we direct the legislature to review the existing caps and update those? Certainly within your purview. But Hillary, your thoughts?
Yeah, so I kind of, this is my proposal, because we have 4 minutes left in this session. I think I would love, and what you might know, if there are other areas that the legislature has looked at something like this. I mean, construction defects is like an example, but I feel like that's not really settled yet. But an area where it's been settled, and maybe we could craft a recommendation marrying the run on the subcommittee with some of the parameters that the legislature used in the past, if we can find them, or some things to consider. So my proposal is to keep this one. I can commit to giving it some more thought and actually putting some effort into wordsmithing instead of trying to do it on the fly with 3 minutes left. So
I
that's my
100%
proposal.
support that. If you're making that an official motion, Hillary, then I second that.
Officially motioned.
Second.
And I see no objection, and I am never going to rush a discussion or certainly a vote. So with 3 minutes to go, Hillary, I'm happy to stay in touch with you. Our next conversation will be Monday the 13th from 9 to 11. I want to thank you guys. I didn't know how we would do getting through what I know are some contentious and issues with passion behind them. What this leaves us with is this, that Hillary's going to bring us some idea. Elizabeth, if you want to bring us language on a proposed alternative to the first one that we voted down, we then have what remains from today's recommendations are 3 definitions, where the subcommittee is recommending that we incorporate directly into Colorado law federal definitions to provide the certainty, given the risk of those changing. We'll bring those into next Monday. What that means is we've got, I think, 3 or 4 ideas from outdoor rec. We've got 5 ideas from housing. We've got a few from government, and we will have these potentially 2 from Hillary and Elizabeth that we'll pick up on Monday. Rep. Ortiz.
Just want to remind us that we also agreed to make room for our own recommendations that we'll discuss and vote on, as well as discuss and vote on how we want to present this to the administration. When I say that, the Polis administration, and then also to the legislature, because I think my words combined with the Lieutenant Governor's words should ring true in everyone's head that putting a 50-page report on someone's desk is just not going to do it.
And I'm going to be transparent with everyone. We have 2 hours on Monday. That's not going to allow me to give you the kind of respectful time that you need. So I'm going to look for another 60 minutes at least next week to do exactly what Mr. Ortiz is talking about. I know we are taking a ton of your time, but given the hundreds of hours that you and the subcommittee have invested to date, I don't want to give short shrift to it now. Elizabeth.
Barak, I'm wondering if sometime before the end of the week, you could just send us all an email that has either an attachment to it or something that just outlines what's remaining.
Yes, we will.
That'd be great. Thank
Yeah.
you so much.
Thank you. Lieutenant Governor, 60 seconds, words of wisdom as we get to the final hill here.
Well, I don't know that I'm the wise one. I sat and listened to all the people that really are the wise people on this. I think it's called the Epiphany. A lot of people think the three kings, the three wise men came today. Anyway, I really feel Rep. Ortiz's frustrations in terms of asking for more time to do things. You know, it's been a long time, and I've been in this fight since probably 1966, before any of you guys were born. Well, maybe not you, Barrick, but and just like President Carter, who wanted to see the guinea worm eradicated before he died, and there's still 11 cases in the world. Some of these things I would love to see resolved before I go, but I also really appreciate the business community's input and the need to balance their concerns. And most of all, it's been a really respectful discussion, and I really appreciate that. So I think that's the way we can really move the bar. So thank you, everybody. We're making progress, so I'm excited. I don't know if Rep. Ortiz wants to add anything else.
No, just that we appreciate you, Lieutenant Governor, for the work you've done. Barrick and Kerry, per usual, just stellar, and also for Dora behind the scenes. I know they don't get a lot of kudos or thanks, but just want to thank everybody that's supporting the work for Barrick and Kerry and for us as we're moving forward. We're getting down to the wire. I do really appreciate everyone's commitment for time and the robust discussion. Even though I don't agree with everybody, I certainly. And even if you don't, even if you think I don't listen, I do hear you, and I do appreciate your input and your lived, and most importantly, your professional experience. So I appreciate everybody. Thank you.
Thank you all. We will follow up by email with the request on the outstanding items. Elizabeth and Hillary, I'll be in touch with you if you'd like to bring ideas for Monday. Otherwise, have a great week, and we will see everyone Monday at 9 a.m. Thanks all.
Thanks, Barrick and all.